answered. We are also recording this webinar so that we can put this on your intranet along with the handbook so that other folks who are not able to join us or are unable to join now because we're running late can access this webinar later. So I've been trying to let you know this whole time that you should have a copy of the handbook, preferably open on your computer so that you can go back and forth between the presentation and the handbook itself, because I'm going to be pointing out certain links that are helpful, and I think that would be a good idea. So what are we going to do? What is the point of this webinar? Well, we're trying to familiarize you all with the handbook. We're going to provide an overview of how to use the handbook. This is not substantive legal training, so I'm not going to be going through the specific workers' rights section, housing rights sections, the substantive legal sections at the end of the handbook. This is more, how do we use this? How is it set up? What are some of the basic parts of this that will make it useful for you? I will do my best to keep up with questions. It looks like I'll have to take questions in the chat box and not by phone, so sorry about that. But if you put the questions into the chat box, I will do my best to answer them as we go along, and I'll pause for questions about every 10 to 15 minutes. Okay. So let's get started. So just to give you a little bit of a background on the Local Human Rights Lawyering Project, most of you have heard this all before. This is a 2-year-long project. We've been funded by the Ford Foundation, and I am the project director of the Local Human Rights Lawyering Project. I am based here at American University Washington College of Law, the Center for Human Rights and Humanitarian Law, the longest name ever. And I am working with now, very excitedly, our 2 human rights coordinators at Maryland Legal Aid and Texas Rio Grande Legal Aid, Rena Shaw at Maryland and Nelson Mock at Texas Rio Grande Legal Aid. And you all likely have been in contact with those folks in your offices. Both are working full-time, dedicated to integrating human rights into your organizations. And by integrating human rights into your work, we're not only talking about legal arguments, but also the client-lawyer relationship and organizational structure. Now, the handbook so far, in its draft format that it is focused on the legal argument portion of our work, but we will hopefully over the next few months be adding sections on the client-lawyer relationship or staff-client relationship and integrating human rights into your organizational structure. And there will be trainings and different events around those ideas as well, or strands as we call them, those strands. So some of the initial questions that I've received about this handbook. First, why does the handbook say it's a draft all over it? There's a watermark saying draft. It says draft in the file name when you save it, etc. So, we wanted to provide you all with a resource and a starting place. But we don't see this as a finished product, because this is the first time we have done any type of project like this. This is the first time anyone's done any project like this, working with legal aid attorneys to integrate human rights into your everyday work. So there have been some legal aid attorneys who over the past decade or so, and even before that, have made human rights arguments in their cases and have used international mechanisms, but there are not too many of them, and we have the case studies that we found included in the handbook. But the idea is that as you go along, you make successful arguments, you develop your own arguments, you find additional resources, you become the case studies, and you add all of that into the handbook to make it more relevant and more useful for your office. And I think this is really important, that this is your handbook, not our handbook. We wanted to pull together the research, which is what we do best as an academic institution, and do our best to make it simple and usable, cut and pasteable. But we now are giving it to you, and we want you to add to it. And I know Rena in Maryland has already sent around a spreadsheet trying to seek input and in terms of, what are the stories, when are you using human rights in your work, and she's trying to capture that. And I think as we go along, we'll be developing more ways to, and methods and how to capture changes, edit, additional resources, additional stories, additional arguments that should be added to the handbook. So another really important point about the handbook, please do not share the handbook with anyone outside your office. And that's why, another reason why it says draft, and another reason why it says please not distribute in the title when you save the document. Initially we wanted to send out the handbooks as password protected. We also, but we decided to just give them to you and urge you not to share the handbook. And this is why. We have an advisory board made up of human rights attorneys and legal aid attorneys from across the United States. And when we first brought this handbook to them, their initial reaction was great, but boy, we hope this doesn't get out in its current draft form. And the reason is they're very worried about anti-international law opposition groups, including groups who are anti-Sharia law, using this handbook to fuel their fire. And as you all may know, there are 11 states who have passed anti-international law, anti-Sharia laws in the last few years, prohibiting judges looking at international law, Sharia law, to inform their decision making. Now, some of these laws are so poorly written, they're vague and likely, ever unenforceable. Others have been challenged by the ACLU and others, but there is this growing movement, and this growing movement has used articles and resources written by some of our advisory board members, including Martha Davis at Northeastern University, and they think that in the wrong hands this could be a dangerous public relations tool for the opposition group. So if we can do our best to just keep the handbook in your office, not even send it to friends or pro bono attorneys. Eventually, we hope to release a version to other legal aid offices and then eventually to the public. But as it stands now, especially in its draft format, not a good idea. So please try and adhere to that, because I think this all depends on us working together. And some things are good to be shared with the world, and some things are better left, in hiding for a while. And please, remind others who are not on this call that that's important, and that we consider it a condition of us having developed the handbook and you all using it, that you agree to that condition. So, what were our thoughts in terms of developing this handbook? We're trying to get practical and usable human rights information into the hands of legal aid attorneys. We wanted every staff member, and legal staff member, paralegals as well, to have the information that they would need to develop human rights law arguments. And I think that a way to do this is in writing, right? And distribute the handbook to everyone and have one place, one resource where you all go to find the information that you need and that you can add to it and share your the success stories and the not so successful stories with each other. So the principles we used in drafting the handbook were simple language. We aimed for as simple English as possible, given that you would have to be explaining these concepts and the arguments to your clients, who often have, a low reading level. So the best to do our best and the outset to make the language as simple as possible so that you don't spend a lot of your time translating, as it were. And then again, we are not worried about repetition here. We really want you to not have to read the entire handbook or even an entire section of the handbook. You may just look at one section, and so we think it's fine if you repeat important concepts. And so that's something to keep in mind as you add to it going forward. So this is simple, not an academic treatise. We want this to be as easy to use as possible, emphasis on cutting and pasting, and uniform citation. And we, we used one format, sort of based on Blue Book, but a little bit different for all of the citations that you'll see, and we encourage you all to do the same. So let's start. At this point, we'll start going through the handbook, but let's see, does anybody have any questions for me that I'm not seeing at this time? Go ahead and pause. Okay. So let's get started. I don't see any questions. So starting with the handbook overview, the table of contents, and I'm gonna not necessarily refer to page numbers because I know that some of you are using different versions of the handbook, so I'll try and use the parts and the section numbers, and I will refer sometimes to the page numbers, but just realize that there are different versions of the handbook even between Maryland and Texas, because even since we released this to you all, there have been several additions, and so it's a little bit confusing, and we're going to have to work with how to manage that. We've had some suggestions, including instead of page numbers, having, Roman numerals, and having a 6.1, 6.2, 6.3 for page 6 if we add to it, so that we don't have to end up printing everything out again. So feel free to let me know what you think about how we should handle that going forward. Ideally, this is all online or on your computer, and you're not printing it out. That would make things better. But I understand some folks definitely prefer to print. So we definitely hear that, and we're going to have to figure out what to do. So this is sort of the overview of the handbook. Part 1, which is in the table of contents. Part 1 includes an introduction to the Center for Human Rights and Humanitarian Law, to Texas, Rio Grande, and Maryland Legal Aid, and also goes into the principles for drafting the handbook, which is what I just went over in the previous slide. Parts 2 and Part 3 of the handbook are designed to introduce legal aid attorneys to the human rights framework and provide the background necessary to begin strategically integrating human rights into your litigation and advocacy work. Part 4 of the handbook is designed to give legal aid attorneys specific information that you might need to make persuasive arguments in state and federal court. And then Part 5, which we're not going through today, is the specific legal issue areas: freedom from domestic violence, labor and employment rights, housing rights. 5.4 is consumer rights, rights to public assistance, children's rights, immigration, family and border rights, immigration, family and DV, and we have added an HIV/AIDS law section just recently. So we encourage you all to cut and paste the sample arguments from parts 4 and 5 of the handbook into your pleadings and briefs and print the corresponding talking points to bring to court. And I'm going to go through that again, but in more detail. So let's see. So part 2. So this is the Human Rights 101 section, and the overview of this section is, what are human rights? What is human rights law? How is human rights law relevant to U.S. courts and U.S. policymakers? So this introduces you to the legal framework, the human rights framework, provides the background to start integrating human rights into your work. And I'm just going to talk a little bit about what's contained in this section. So, the principles of international law is formed by written documents as well as common practices. So, in terms of how do we define international law? What are the documents and practices? We have international conventions. We have international custom as evidence of general practice of law, and judicial decisions and teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of rules of law. So conventions, custom, judicial decisions, those are the sort of main 3 portions. And then, in terms of these sources, Chapter 2, Section 2.2 is International Conventions. Chapter 2.3 is Customary International Law, International Custom. And then Section 2.4 is Decisions of International and Foreign Courts. And then, 2.5 is General Principles and Guidelines, and it specifically defines what are general principles and guidelines and how those differ from international conventions and customary international law. So let's see, okay, so I'm gonna just pause there. Any other questions? I'm not seeing questions, so please let me know if you. Just please enter a question if you do have one, and I'll do my best to answer. So part 2, section 2.2, we have the sampling of conventions in the UN system. So this provides the name of the treaty, a description, a little bit of history, and then the proper citation that we're using throughout the handbook. Okay, and that's again this. In section 2.2, this citation is the same as you're going to see in every section, including the substantive legal section. And then we have the date, and the date listed in the date column refers to the date the instrument was opened for signature. And then the U.S. action, for example, ratified, not available, none, or signed only. So that's section 2.2.1. And then 2.2.2 is going through the sampling of conventions in the inter-American human rights system. So these, if you're looking at this document either in Word format or in PDF format, you can cut and paste these citations. And that was the idea here. You can always go to these sections whenever you want to add a treaty to a pleading or to any kind of materials that you're pulling together. You can come here, cut and paste really quickly. You don't need to go look it up. The other thing I want to point out here is the hyperlink. Right here, the full text of the OAS Charter. Every treaty or declaration that's listed here, you just can click on this hyperlink in your, well, here I clicked and it went to the next page, but you click on the hyperlink and it will take you to the full text of the treaty. So when we were in Texas last week, someone had asked us for, where to go to find the full text of the treaties. Well, if you go to the handbook and you go to these sections, sections 2.2.1 and 2.2.2, we have the full text of the treaties linked here. So they are also linked in the substantive legal issue sections in Part 5 as well. So anytime you see this underlined blue text, that means that there's a hyperlink, and even in the PDF format, you should be able to click on that hyperlink, and it should take you to the resource or the text that we're talking about. Now, please let me know if for some reason the hyperlink that you're clicking on is not working. That's probably because there's a extra space in there or something that we need to fix. And we've gone through the draft, but there's always mistakes somewhere that we've missed. So please let me know if you find any broken hyperlinks. Okay, and again, Part 2, Section 2.5, these are the general principles guidelines section. And I just want to point out that these are secondary evidence of human rights law. Each of the substantive legal sections in Part 5, housing rights, labor and employment rights, each of those sections contains not only the list of human rights law conventions and treaties and the judicial court decisions, both from international courts, foreign courts, both from regional bodies, but also contains the general principles and guidelines. And these are useful, again, as secondary evidence of human rights law. So think of these as similar to reinstatements or model code or Black's Law Dictionary. These are not binding, but the language can be right on point. You can also sometimes find a distilled explanation, just like in reinstatements or model code. And these may even be evidence of customary international law, but I would look to other sources as well. But so when you see, for example, the Boston Principles in Section 5.7.8, or the United Nations Guidelines for Consumer Protection in Section 5.4.3, these are evidence of secondary sources of human rights law. Okay, so going into Part 3, again, I'm not seeing any questions so far, so please let me know if you do have questions. We have the strategies for effectively using international human rights in your everyday advocacy. So on the version I'm using, this Chapter 3, Part 3 starts on page 18, but again, it may differ for you all. This chapter is designed to provide you with a variety of different strategies to apply the human rights framework. So these are different alternative advocacy avenues. So 3.1, we're looking at human rights monitoring, documentation, and fact-finding, which can lead to the documentation, the data necessary to advocate for your clients with treaty monitoring bodies, special procedures, etc. So the Human Rights Council is a specific example of a human rights monitoring body which legal aid attorneys might advocate before through its Universal Periodic Review. It's covered in Section 3.3a. Or advocacy before special procedures covered in 3.4 with special rapporteurs. And I know some of you have been writing the letter to the UN Special Rapporteur on Extreme Poverty regarding migrant camp access. So if you wanted to look at that section to look into what are special procedures, how are they appointed, you can also look at each special rapporteur has its own web page section of the United Nations website that talks about their background, their bio, their mission, all of the reports they've submitted to the General Assembly, their thematic reports, their country reports. Really great resource, and we've provided some links to those. Lastly, Section 3.5, how to bring a case before the Inter-American Commission on Human Rights. Now, the Inter-American Commission on Human Rights is an international treaty monitoring body, And here's individual cases brought against the U.S. for violation of human rights. This is the only sort of international court-like structure that it will hear cases by individuals brought against the United States. And the Inter-American Commission on Human Rights sits here in Washington, D.C. And that section of the handbook was written by Carrie Bettinger Lopez, who brought the Jessica Gonzalez, now Jessica Lanahan case before the Inter-American Commission on Human Rights, which is formerly the Gonzalez v. Castle Rock case, which went up to the Supreme Court regarding she had a domestic violence and a protection order that she had, and the police and officials in Castle Rock failed to protect her and her children from her husband. So so Carrie brought that case on behalf, along with others, but she was lead counsel to the Inter-American Commission after Ms. Gonzalez had lost in the U.S. Supreme Court. And so she wrote that part of that section, very based on her experiences, and she's also been involved in other cases before the Inter-American Commission. So let's see, Part 5. Human rights litigation in the U.S. So I would say Part 4, reading it wrong. Part 4, the human rights litigation in the U.S. section, is probably the most important chapter in the handbook in terms of where to dive into human rights litigation in state and federal courts. It's designed to give you the specific information you need to make persuasive human rights arguments in court. The arguments are designed to supplement your state and federal law-based arguments, so they're in addition to, do not replace your state and local arguments. Let me see, I have a question. Okay. So here's the question. Are there in domestic or international organizations that regularly submit shadow reports to UN bodies on the thematic areas that legal aid attorneys work on, housing, consumer law, public benefits, etc.? The answer to that is yes. When the U.S. The Universal Periodic Review occurred in 2010, which is a review by the United Nations Human Rights Council of the U.S.'s complying with or not complying with its obligations under all of the human rights treaties of the Universal Periodic Review. About 400 domestic organizations submitted shadow reports or collaborated together to submit shadow reports. Many of the shadow reports were on issues like housing rights, like child custody issues, like health care, access to justice. So yes, I would say that there is a history of organizations here in the U.S. participating in the treaty body monitoring process. So legal aid has, legal aid organizations themselves have remained mostly silent. So, and legal aid clients specifically. So we're, encouraging you all to collaborate with organizations that are already putting together shadow reports to add your own stories, your own data, your own information that you would like the world to know about. And we're going to be having specific training regarding using the treaty body monitoring process for the different treaties as they come along. We had one in March regarding the ICCPR, the International Covenant on Civil and Political Rights and the upcoming U.S. review, which will happen next year. So we had that training, and some attorneys from Texas and from Maryland went to that training. We'll be having other trainings. The UPR process for 2014 will be starting up, and I'm sure we'll be having some trainings on that. Also be specifically looking at how to bring a case before the Inter-American Commission and having live trainings and maybe webinars on that as well. Okay, so in terms of part 4 of the handbook, there are actual arguments, cut and pasteable arguments of why human rights law is relevant to a U.S. local or state court, and I encourage you to cut and paste those arguments into your pleadings or briefs and print the corresponding talking points to bring with you to court. Specifically looking at part 4.1, section 4.1, so international human rights law is difficult to enforce directly in U.S. courts. That's the title of this section. Just want to emphasize, these human rights law arguments are not meant to be your only arguments. They're meant to supplement your state law arguments or your federal law arguments. And I think you can look at the case studies in the substantive legal issue sections and see how legal aid attorneys and other attorneys have used human rights in domestic courts, and see that it's always as a supplement, it's always as an additional tool to build a stronger case. And I think that's a really important thing to remember when you're going through the handbook and looking through all of this. So international human rights law, so human rights treaties are non-self-executing, meaning there must be implementing legislation passed after the ratification of the human rights treaty. And the only human rights treaty that the U.S. has ratified and also passed implementing legislation for is the Convention Against Torture, and we passed the Torture Victims Protection Act, which has done some good things. But the legislation and the reservations, understandings, and declarations that were passed with the Convention Against Torture and the other two conventions that we have ratified, the ICCPR, International Covenant on Civil and Political Rights, and the third, the Convention on the Elimination of Racial Discrimination. All three of those we have passed reservations. We have enacted reservations, understandings, and declarations, which cause major problems and state that the treaties are non-self-executing. So again, there's the other common reservation, understanding, declaration is that there's the treaties may not be directly enforced by private parties in court, so no private right of action. But that doesn't mean that this is the international human rights law is not relevant and not persuasive to state court judges. Also remember that customary international law does not require implementing legislation. So if you have customary international, which is jus cogens, where there's agreement that the international community, for example, torture, for the prohibition of torture at the international level has been recognized as reaching the level of jus cogens. It's customary international law, and you could point to that. That customary international law is controlling in court, and you could, use that. But that's getting a little ahead of myself. But anyways, for example, jus cogens, the prohibition against torture doesn't require implementing legislation, but to directly enforce the treaties and the conventions in U.S. courts, you need implementing legislation according to the reservations, understandings, and declarations that the U.S. submits when it ratifies. Part 4, Section 4.2, so this section looks at 5 main arguments of why human rights law is relevant to state courts. And I've laid them out here. They're also in your handbook. And, you know, I think that it's really an interesting, this comes from Martha Davis, who's a professor up at Northeastern, who I mentioned before, is on our advisory board. And she wrote an article encouraging legal aid attorneys to use human rights law in their work here in local and state courts, and these were the arguments that she made, and they've been extracted from her article and put into the handbook. But I've been talking to all sorts of different folks, legal aid attorneys and human rights attorneys, and it's really interesting to go through these arguments with different sets of folks and hear their reactions to this. I think it's a very interesting exercise. I just this morning was speaking with a group of human rights attorneys, many of whom work abroad, are not they're not human rights attorneys here in the U.S. They're human rights attorneys in Laos and Vietnam and other countries, and you know, some of this they had lots of questions about. And some of it they really thought sounded great, and I think you know, and I think that's true of judges as well, that some of these arguments will work with certain judges, and some of these arguments won't. We all can think of a judge who you would not want to say the words human rights to, or let alone any kind of right to housing or right to health care, that would just, you know, the judge would immediately close her ears and not hear anything else of what you said, and you know, yell at you and send you out of court. You know, I had a judge who, I cited the U.S. Constitution, and the judge, you know, said, "What are you doing? Yeah, that federal thing doesn't belong in my state court." So a judge in a little town in Louisiana. So that's not the judge that you want to make the argument that state courts should be part of the transnational dialogue on human rights because it's a vital conversation that promotes universal values. I mean, that's probably not what you want to say to that judge. But you can think of judges that when you're trying to explain why it's relevant, you know, what the custom of other countries is, or what international practice is regarding, say, the, you know, right to water and sanitation and a tenancy, you can see that some judges will really connect with your argument that it's a human rights violation, and that, you know, other nations have all come together and agreed that the right to water and the right to sanitation is part of what you get when you rent a space. So food for thought for all of you and, you know, your colleagues moving forward. So section 4.2 has these arguments, these sort of bigger points, but then also these cut and pasteable sample arguments. And the idea is, again, even with the PDF document, you can cut and paste these arguments into your pleadings. We tried to make the citations as clear as possible, as uniform as possible. You can always change these, or, you know, only take part of these sample arguments, whatever you think would work best for your particular case. But we wanted to give you an idea of how to make the arguments not only specifically about the legal issues, the substantive legal issue areas, but also just generally, how would you explain that this human rights law is relevant? Okay, so let's see, moving on. This is another example. So this was from the right to housing section. So I'm just trying to show you how the arguments in Chapter 4 build up to these specific substantive legal issue area sections. So you wouldn't want to necessarily start with this. You need to first explain the right to adequate housing as defined by international law, blah, blah, blah. You need to explain first where, you need to bring them into the fold and explain why we're even talking about human rights law and the right to housing and why that they should pay attention to the rest of what you're going to say. So, it may be a longer, it may end up being a longer section. It may end up being first this sample argument, and then you add the right to housing, the specific issue area argument. These can definitely be shortened pretty easily. Some of the substantive legal issue areas arguments are shorter than others too, so we tried to give you a variety. So this will be what the full sample argument would look like. It's just combined that the sample argument 4 that I was, or sample argument 3 that I was first talking about, the Charming Betsy Doctrine and the Vienna Convention, and then it goes into the housing rights specific argument. Okay, and moving on again. And I know we have gone past our time of 1:30. I'm hoping to wrap this up in the next 10 minutes or so, so bear with me. Thank you all for taking the time out of your busy days to listen and participate in the webinar. So I just wanted to show you an example. This is a sample table of contents from a state law brief. This is from a brief filed in the Maine Supreme Court on behalf of Leo Bellinger by Pine Tree Legal Services last year. And it included an international human right to housing argument. There's a link to this brief at page 87 of the housing rights section. It's in the housing rights section. It may not be exactly on page 87 for all of you, but the housing rights section is section 5.3. And it should be at the end where the links to the briefs are. So as you can see, the human rights argument is added in, and it's only one section of the brief. It's sort of this particular case. They were looking at local law regarding the warranty of habitability and whether or not the right of water and sanitation was, a part of the warranty of habitability in local law in Maine, and then they looked at national standards, and then they looked at international human rights law standards and whether or not international human rights law recognized the rights of water and sanitation as part of a tenancy. So they're building a case and going from local to national to international and really putting this case in context. This was a case, a gentleman who lived in a mobile home, who had lived there around 12 to 15 years, and there'd been no repairs made. In the meantime, his water and sanitation disintegrated, and he was having to, his connections disintegrated, he was having to carry his sewage from his mobile home a half mile and dump it. It's a dumping station, and he stopped paying his rent because of all the problems, and they filed an eviction suit. He responded saying that he had no water and sanitation, and they went all the way to the Supreme Court, and this attorney who was a legal aid attorney from Pine Tree Legal Services wanted to show that even though this is a case about $300 in rent, that this is a much bigger issue, and wanted to connect this right to housing, right to water and sanitation case, and this one gentleman in the mobile home, with a worldwide right to housing movement, and really showing the judge that this is, a housing right, a big deal, and it worked. They won in the Supreme Court. The decision did not reflect her international human rights law arguments, but the gentleman who lived in the mobile home, won. So, and that's clear. It's now very clear that even for folks renting mobile homes, the warranty of habitability in Maine includes the right to water and sanitation. Okay. So Part 4, Section 4.3, special considerations when the government is not a party in the suit. And I wanted to point this section out because this is very important. International human rights conventions, by their nature, bind governments. They're basically contracts between governments and not private parties. And so usually when we talk about human rights violations, there has to be a government actor. But there can be times when human rights arguments are relevant when the government is not a party in a suit. And in terms of examples, well, the case I just mentioned was definitely an example of that. That was a case between a gentleman, a landlord and a tenant, and neither of whom are government actors, but in that we were looking at policy and the law, and making arguments about the law and interpretation of the law. So that's one example. Other examples are, say, a divorce case where one party might argue that a local statute discriminates against women or same-sex partners. So when you're looking at the law, you can look at whether or not a law should be interpreted one way or another based on being consistent or inconsistent with human rights law. Or if you're trying to expand the law, you can use human rights law to argue for expansion of the law, etc. Those are just a couple of examples, but you do need to be especially careful and think through your arguments and your strategies when the government is not a party to the suit, which is going to be a case for most of the legal aid cases. Okay, and lastly, Part 5. Again, I'm not going to go through each of these specific legal issue area sections. However, these are what we have. We also now have an HIV/AIDS law area, which is not in the handbooks that you all have, but we'll be distributing that shortly. And I again encourage you to cut and paste the arguments, the sample arguments from both Parts 4 and Part 5 of the handbook into your pleadings and briefs, and print the corresponding talking points. And then lastly, each of these legal issue sections include an introduction to the legal issue area and the related human rights, quick statistics and resources for data, a sampling of relevant human rights law, a sampling of relevant state and federal court cases, and cases before international and sub-regional bodies or national courts. So like the Supreme Court of India, for example, Supreme Court of South Africa, or it could be the Inter-American Commission, what I was mentioning before. And then there are some relevant state and federal court here in the U.S. cases which have looked at human rights law, and so those are listed where they exist for that particular issue area. There's also a sampling of treaty body and special procedures commentary and recommendations, sample arguments, sample talking points, relevant case studies of legal aid attorneys using that particular type of human rights law in their work, and there's links to sample briefs and petitions, again, where we were able to pull those together. And going forward, hopefully we'll have from you all, as you use the human rights law in your work, we will have additional sample briefs and petitions. Then we also have other useful resources, such as other handbooks and other guides. So let's see. So, again, I'm just going through sort of reiterating the different human rights law. So human rights law, we have ratified treaties and human rights instruments not ratified by the U.S. These are split up for each of the substantive legal issue sections. So the ratified treaties come first, and then the human rights instruments not ratified come second for each section. And then we've pulled out relevant provisions for each of the treaties, or relevant articles. But that doesn't mean that those are all of the articles in that treaty that might be relevant, because then this handbook would have been 500,000 pages. These are just the articles that we found most relevant. Now, if you see something that we've missed in the treaties, you should take a look at the treaties, especially the treaties for the issue area that you focus on. For example, if you're a SENA attorney, you might want to read the Convention on the Rights of the Child and the optional protocols at some point. And if you find that we have not put in an article in the handbook that you think should be in there, let's add it in. So there are articles that we found relevant are there. We have case law. I went through that before. The treaty body commentary and recommendations, the treaty bodies that are charged with interpreting and enforcing the treaties. And a lot of these substantive legal issue area sections include treaty bodies for treaties that we have not ratified the treaties for. But if it is coming from the Human Rights Committee, which is the treaty body that oversees the ICCPR, or the Committee on the Elimination of Racial Discrimination, or the Convention Against Torture Committee, if the commentary recommendations come from those committees, the commentary and recommendations are binding. So do pay attention to that. The special procedures commentary and recommendations, these are the special rapporteurs, their reports, their recommendations. They're arguably binding, but often more like persuasive language. And we've done our best to pull out some relevant commentary from the special procedures as well for each of the substantive legal issue sections. You saw these before, but these are what the sample arguments look like and the talking points. I just pulled out an example for you all from the children's rights section. And we did our best to try and put the talking points easily printable, but sometimes they're going over pages. So let us know if that's not a good idea. If you want it all on one page, let's just add some pages in to make this easier for you to print out. There's also the sample briefs and petitions, as I mentioned, like the Leo Bellinger case that I was speaking about, the mobile home. We have a link to that. We also have petitions before the Inter-American Commission filed by other groups, including the ACLU. We also have Carrie Vettinger Lopez's brief in the Jessica Lanahan case. We have a link to that in the domestic violence section. We have other resources. A section of each of the substantive legal issue areas is sort of the catch-all section. So sometimes there are other human rights advocacy guides. For example, this Human Rights and Domestic Violence Advocacy Manual, which is in section 5.1.8. Sometimes there are reports. For example, the reports listed in the Labor and Employment Rights section 5.2.8. Also, we have put in some articles, clearinghouse review articles, law review articles. I would encourage you all, I'm not sure we have any blogs listed there or linked to there now, but I would encourage you to add. And then other collections of relevant resources. Also, all sorts of different resources have gone into that other resources section, and I encourage you to add as you find additional resources. And again, these blue underlines, this blue underlined text is a hyperlink, so you can click on any of these and go find the resource online. So again, a reason why I encourage you to use the handbook in PDF or Word format on your computer as opposed to printing it out, because you are able to click on these links easily. So that's about all I have for you today. Sorry that we have run over time a bit. Let me know if you all have any questions now. I'll give you a couple of minutes. Otherwise, thank you so much for attending. We will be having these webinars on a monthly basis going forward, so encourage other folks to attend. We'll make sure to allow audience questions next time. And I'm going to be sending you an evaluation, and be sure to be frank with me and let me know what we can do to improve this. Obviously, using the correct software is the starting point, but any other sorts of comments or additions, suggestions would be much appreciated. So I don't see any questions, so for now I'm going to go ahead and sign off. Thank you all again for attending, and good luck to you using the handbook going forward. Feel free to email me if you think of any questions going forward or in the future. Thank you so much again. Bye.